Well, tonight, Hunter Biden says that he's going to plead not guilty to 3 felony gun charges. Now, it comes as the GOP-led House committees are preparing to amp up their own investigations into Hunter Biden and, of course, his father, the President of the United States. And there's new testimony from the FBI and also IRS officials that are casting doubt on key claims from an IRS whistleblower who alleges that there was some political interference in the federal investigation of Hunter Biden's taxes. Joining me now is Tristan Leavitt. He's an attorney for IRS whistleblower Gary Shapley. Tristan, thank you so much for being here tonight. This is continuing to be a very big story, and I'm glad to have your insight in particular. You've obviously heard, Tristan, that there are new witnesses out there that are now rebutting 2 of the key contentions made by your client about David Weiss, that he said that he was, quote, not the deciding person, and that he was denied a request for special counsel status. What's your response to these different recollections?
First off, to be clear, out of those new interviewees, the only other one who took notes was Special Agent Shapley's immediate supervisor, and he said that he's long since shredded those notes. But his contemporaneous response to Special Agent Shapley back on October 7th, 2022 was to say, you covered it all. And he also acknowledged in the interviews this week that if he thought that Gary was lying or misleading on anything, he definitely would have corrected that with their supervisor who those notes went to. But on the substance, there are 2 key points that I think are important. The first is that all of the other interviewees acknowledged in their interviews that they were not familiar with the testimony that Attorney General Merrick Garland gave before the Senate Appropriations Committee 5 months before this meeting in question. Because in that hearing, Garland was grilled by Senator Haggerty on whether Biden political appointees would be involved in Weiss's approvals in the Hunter Biden case. And Garland's #1 response was they put the investigation in the hands of a Trump appointee. So Special Agent Shapley was very aware of that testimony going into the meeting. And I think that helps to explain why others, for whom this meeting was a year ago and not particularly significant to them because cases have been declined in D.C. and California throughout, that's why this stood out to him more than others. The second key point I'll just add is, regardless of the specific wording, all of the attendees testified that most of the meeting was spent discussing whether the D.C. and California U.S. attorneys would let Weiss bring charges in their district, and that if he couldn't, Weiss would have to follow another process seeking special authority, which is exactly what we've seen he's done in seeking special counsel status.
Well, for the non-lawyers, this idea of contemporaneous notes, I want to just revisit for a moment, because it actually is what you use in some respects to actually decide who has credibility or not, what amount of weight to give to someone's statements or testimony. We believe that if it's written down close in time to the event, that it has greater weight, greater credibility, less of an opportunity to try to insert lies or falsehoods or misrecollect some things. So I understand that point. But the other aspect of the recollections, Weiss himself twice spoke or wrote to Congress prior to, of course, being elevated to special counsel. And his recollection, of course, was that he did have the authority. He was not undermined or hamstringed. How does that factor into the recollection of your client, among others, to suggest that somehow he was not accurate?
So I think it's important to understand there are 2 different phases of the investigation, we'll call it. So the underlying investigation, Weiss has never spoken about. That's the part of the investigation where Special Agent Shapley and Special Agent Ziegler said they were blocked from taking investigative steps. A lot of that had to do with Assistant U.S. Attorney Leslie Wolf, and Weiss has never spoken about that. So that's the you can't ask about the big guy, don't ask questions about the dad, all of those. Weiss has written about this prosecutorial phase where he was trying to bring charges in other districts. And I think it's important to recognize that he himself has acknowledged in his letters, he actually wrote 3 to Congress, 2 to Chairman Jim Jordan and 1 to Ranking Member Lindsey Graham on Senate Judiciary. And he told Lindsey Graham he had, in fact, sought or had discussions with the department about special charging authority months before this meeting. Now, Gary Shapley is an assistant. He was an acting assistant special agent in charge, but he would have no reason to know that from the U.S. attorney with whom he had very little contact unless it was actually discussed at that meeting. So people can argue that he took away a different understanding, that they discussed that authority and not that he'd been asked for it. But again, all of the attendees that have been questioned have agreed that the facts are clear, that the D.C. U.S. attorney declined to bring charges. That threw up a roadblock for Weiss. Then the meeting was to discuss whether the California U.S. attorney for the Central District would allow bringing charges. And if he didn't, that Weiss would have to go to the attorney general and seek this special authority.
In any event, as we know, sitting here today during this conversation, guess what? David Weiss now is special counsel. He has that authority, and we have at least now 3 indicted charges against Hunter Biden. But let me read for you a portion from the Hunter Biden lawsuit. And this is, of course, not naming your client or the whistleblowers in this actual suit against the IRS, a very important point to note. But here's what it says, I'm quoting, "These agents' putative whistleblower status cannot and does not shield them from their wrongful conduct in making unauthorized public disclosures that are not permitted by the whistleblower process. In fact, a whistleblower," they write, "is supposed to uncover government misconduct, not the details of that employee's opinion about the alleged wrongdoing of a private person." I'm curious as to what your response is, given that they're not actually named in the suit, but clearly they are part of the substance of the argument against the IRS.
Yeah. So there's 2 parts of the whistleblower protection. I was appointed by President Biden to the Merit Systems Protection Board, which protects whistleblowers like those in the IRS, and those protections apply across the government. What made this case unique was that these whistleblowers had special confidential taxpayer information, and that is governed by a more specific law than the Whistleblower Protection Act I dealt with on the Merit Systems Protection Board. That taxpayer protection statute, written by Congress, gives Congress the authority to receive that information, and if it chooses to release it, like it did with President Trump's tax returns less than a year ago. So the whistleblowers here did not share this information in any way outside of that confidential process with Congress. Once Congress made the decision to release it, that's public information. And so they have spoken about that since then, just like any private citizen could.
An important point to raise, and of course, it wasn't, from my understanding of the facts of this case so far, you, of course, far more well-versed in it, according to your client, that it wasn't as if Congress had not asked for the information, but a whistleblower can often be a confusing notion. How much protection is guaranteed, what can be said, and to what extent. But again, they're not named in the suit. Tristan Leavitt, thank you so much for your thoughts and insight tonight.